Before we begin, I just want to let everyone know, since we do have a lot of people who are here to testify, and we do want to hear from everyone, that there will be a 3-minute time limit. And I know that I'm usually generous with that, but today, since we do have a lot of people, I am going to stick to the 3 minutes. So, I will say time to finish your thought or your sentence, but then we're going to move on. So I would appreciate your understanding of that for today. So the first people I'm going to call up are Mike Davis from News Guild of New York, Lauren James Weir from New Jersey Press Association, and Barry Bender from Green Party of New Jersey, all opposed, wanting to testify. Oh, and just you guys can come sit. We're just going to do roll call. Thank you. This is a roll call for the Assembly Appropriations Committee for May 10th, 2024. Assemblyman Bach.
Present.
He's present. Assemblyman Ock.
Present.
Assemblyman Cohen. Assemblyman Weber.
Here.
Assemblywoman McCoy. Present. Assemblywoman Tucker, substituting for Assemblywoman Gator. Present. Assemblywoman Leonard. Here. Here. Assemblyman Atkins, substituting for Assemblyman Scherer.
Present.
Present. Assemblyman Rodriguez, substituting for Assemblywoman Intermera.
Here.
Here. Vice Chair Reynolds Jackson.
Present.
Present. Assemblywoman, Chair Swing. Here. Is here. We have one. Thank you. Okay. Who would like to start? Okay.
Hi, good going through. Just real quick, I sat through hours and hours of Senate Budget Committee, and I got to come in the back of the line every time, so we're already off to a good start. I appreciate it. Good afternoon, everyone. Thanks for the opportunity to speak today. My name is Mike Davis. I am the acting unit chair of the APG-MCJ Guild, a labor union part of the News Guild of New York. We represent the journalists at the Asbury Park Press, the Home News Tribune, and the Courier News. Nobody in this room is denying that OPRA has to be updated, to be modernized, which is the word that we keep hearing. But even with these amendments, you're still being asked to consider a bill that is fatally flawed at its very core. Supporters of legislation will tell anybody that will listen that this will not impact members of the public, members of the press. These amendments go out of their way to make special exceptions and custom breaks for commercial requesters, but I'm here to tell you that members of the press, members of the public will unequivocally have a harder time accessing public records under this bill. And again, somebody mentioned it here yesterday, and it's important to say it out loud as much as we can. Public records. They are public records that belong to the public. I forced your colleagues in the Senate to listen to a laundry list of stories and the great journalism that is out there that could not be done without OPRA. I'm going to spare you the laundry list because it's Friday. They have a lot of people that want to talk. I'm going to focus on one example. 2020, me, my colleagues at the Asbury Park Press and Bergen Record, we published an investigation into private school bus companies. These companies that put reckless drivers, in some cases, literally a registered sex offender behind the wheel of school buses to transport kids to school every day. When they got caught, they would just dissolve their LLC, start a new one, put it in the name of like an uncle or a brother, get another contract, none the wiser. Chairwoman Swain, this should sound very familiar to you because you and Senator Tully and Senator Logano were the chief sponsors of legislation to stop this behavior, and that legislation became law. You should be proud of that law. I am proud of that law. We will leave the discussion why the executive branch is dragging their feet doing anything about it to another day. But I can tell you directly, the work we did on that story that led to those changes could not have been possible under the changes proposed in this bill. We would have been denied records every single step of the way. We were hit with outrageous fees that we had to fight back. That would have been much harder. It's just a story that does not get done. This is the kind of stuff that's possible under OPRA, and I think there would be a lot more of it if we had a real frank conversation about how to update OPRA and modernize it. We shouldn't be talking about restricting access to public records. We should should be talking about opening up that access. We're behind Florida. Like, Florida is better at this than us, and that makes me so mad. Transparency is not dangerous. Transparency is healthy for democracy. I think everybody on this panel will probably agree with that. What really scares me is that there are parts of this bill that don't just make it harder to obtain records, they actually like serve to scare people away from getting involved in the process. You've heard a lot about fee shifting over the last couple of weeks and months. It just makes it really, really hard to pursue a perfectly valid legal challenge when your records are illegally or unreasonably denied. That's a problem. If you do wind up in court under the amendments in this bill, now the onus is on us to prove why we shouldn't be charged an outrageous fee. That happens to everybody. My colleagues in the press row, find any of them, they will tell you about some $1,000 fee they totally try to charge them for the simplest of tasks.
Okay, that's fine.
I'll just wrap up and say at its core, even with the amendments, this makes it harder for the press members of the public to access public records. A vote for this bill is a vote to restrict access to public records. Thank you, Simon.
All right, thank you for your testimony and for your reporting. Next.
Good afternoon. My name is Lauren James Weir. I'm an attorney at Gibbons. I'm also co-counsel to and a lobbyist for the New Jersey Press Association. We've provided the committee with a position paper that outlines some of the most problematic provisions of the bill from the Press Association's perspective. But I'll focus my testimony today, given the time constraints, on the financial issues and the financial aspects of probably the most devastating provision of the bill, which is the removal of OPRA's enforcement mechanism, which is the mandatory fee shift. The changes made to this provision now provide for a discretionary fee award, except in those situations in which the public agency is acted in bad faith. This standard is problematic for a couple of reasons. First, without a mandatory fee shift, requesters are just not going to challenge wrongful denials of access. The majority of requesters, they simply just cannot afford to risk shouldering the burden of the cost of enforcing the act and holding public agencies accountable to follow the law, and they shouldn't have to. Second, in those cases where a requester can actually afford to bring a challenge, the bad faith standard will not only present a significant hurdle for the requester, but will also result in additional litigation costs than under the current law. Currently, attorney's fees under OPRA are only awarded after a judicial finding that there has been a wrongful denial of access and that the fees are reasonable. These prerequisites are clear, easily applied by courts, and already ensure judicial oversight on the availability and the amount of fees. The bad faith standard, which is not defined in the bill, will inevitably result in discovery, including depositions, to develop a record into the motivations and the intent behind the denial of access. This will increase the public agency's litigation costs, the requester's litigation costs, and ultimately the fee award if one is granted. The suggestion that a cap on the hourly rate is the solution to the fee award issue is misleading. Currently, courts that award mandatory fees under OPRA routinely reduce, either through reducing the hourly rate or reducing the number of hours billed, or both when they arrive at what's a reasonable fee to be awarded. If the idea is the implementation of a static fee cap, which can then be further reduced through the discretion of the trial court or the GRC regarding the number of hours billed, then NJPA does not think that that's a viable solution. However, if what we're talking about is implementing an hourly rate cap subject to a COLA and providing some sort of limitation on further reduction of any fee award, then NJPA is open to a conversation. NJPA has submitted to Assembly and Senate leadership a proposed compromise that we think addresses the issue. I have copies of that language if anyone's interested. NJPA, as always, stands ready, willing, and able to work with legislators and stakeholders on such an important piece of legislation. Thank you.
Thank you for your testimony.
Hi, I'm Barry Bender. I'm a co-chair of the Green Party of New Jersey. I was here previously, before the amendments. An important word that we have to talk about is transparency in government. It's critical to all the public that our government be transparent, that they feel that they have trust in their government. And I'm going to go into what I said last time I was here. At all levels of government, people are losing faith and continue to lose faith in their government. If you look at the outcome or the percentages of voters in the last few elections, I know in my county, in the last general election, we had a 20% turnout of voters. As people get more and more the feeling that their government doesn't listen to them, like I'll give you the example when I go knocking on doors campaigning. So many people say to me, well, I don't vote because they don't listen to me. An attack on transparency, which is what I see this bill as, an attack on transparency, is not going to bring more voters in. We're going to get lower and lower turnout to the point where there's going to be very few people voting, and you know, there'll be a small group installing government, and at that point, hopefully the people wake up and decide to come out and vote and go against those who would be non-transparent to the public. And the Green Party of New Jersey is there waiting when that time comes. Thank you.
Thank you for your testimony. All right, next we will hear from Janie Vinnick from the League of Women Voters of Morris, Evelyn Murphy, also the League of Women Voters of Monmouth County, and Zach Doherty from the League of New Jersey. Who would like to go first?
Good afternoon, Chairwoman Smith, Vice Chair Reynolds Jackson, and members of the committee. My name is Zach Doherty, and I'm testifying on behalf of the League of Women Voters of New Jersey. We are here today to oppose Bill A4045. As a community organizer, I want to share my firsthand experience engaging with the public, your constituents, over the recent months. Their collective outreach towards this bill has been palpable and resounding. Despite efforts to amend this legislation, this bill continues to create unnecessary barriers and obstacles to accessing the public records. In addition, our members and the public have not been given adequate time to review the proposed amendments and continue to express significant concerns with the direction of our democracy in New Jersey. To use the analogy, where there's smoke, there's fire, the same is true of this legislation. Where there's legislating in the dark, there's likely a flawed bill lurking in the shadows. The amendments fail to address the League of Women Voters of New Jersey's core concerns regarding this legislation. There are too many components of this bill that make it harder for the public to access public records. One of the areas that is most troubling to us and to many of our partners is the guts to fee shifting. We've made it clear that fee shifting needs to stay intact for the protection of New Jersey's Open Public Records Act. Without fee shifting, regular members of the public will not be able to access legal representation when records are improperly denied, which we know happens frequently. We will not support a bill that erodes the public access in this way. This bill creates additional and unnecessary hurdles for the public, including putting the burden on the public to prove a fee from an agency is unreasonable, prohibiting the public from requesting records from multiple agencies, and asking for different levels in request. What is worse is the public continues to face vague and unclear threats of lawsuits, and ultimately members of the public will be less likely to request the public records they are entitled to, and if they do not make requests and are wrongfully denied, they have less ability to pursue legal action. This bill also does not accomplish its stated purpose of modernizing the Open Public Records Act. It falls short of introducing changes that would help improve OPRA and make it more efficient to access records, to help understand government activity, and to hold government accountable. Instead, this legislation creates significant, unnecessary hurdles. League members want an active, engaged democracy that works for the people. The legislature should be moving forward on good government issues by increasing transparency instead of making it more difficult for the public to be civically engaged. I urge you to stand up for democracy and vote no. Thank you.
Thank you. Next.
Good afternoon, Chairwoman Swain and members of the committee. My name is Janie Bennett, and I'm testifying on behalf of the Morris Area League of Women Voters. Our league spans numerous municipalities in Morris County, including in legislative districts 21 and 25. The Morris Area League is also strongly opposed to Bill A4045, which is before you today. I do want to avoid repetition. I'm not going to say the same thing as my colleague, but suffice it to say that the Morris Area League agrees fully with the positions stated on behalf of the State League, as well as in prior hearings, the ACLU and our other pro-democracy partners. We strongly believe this bill is designed to both deter and impede the public's ability to obtain government records. But I want to focus on and highlight highlight one specific provision that even after slight amendments to it, I believe contains a loophole that's arguably large enough to make it impossible for any requester to obtain almost any type of written communication that's supposed to be generally accessible without facing likely litigation costs. The provision states as follows. A custodian shall not be required to complete a request, including for, but not limited to, mail, email, text messages, correspondence, or social media postings and messages, if the request does not identify a specific job title or accounts to be searched, a specific subject matter, and is not confined to a reasonable time period, or if the custodian determines that the request would require research and the collection of information from the contents of government records and the creation of new government records, setting forth that research and information. Now, the problem with this is, if a requester is mandated to ask for only communications that are narrowly tailored to specific subject matter, specific title account, and specific time frame, then by definition, the person complying with that request needs to do research to collect that narrowly tailored information from documents that don't automatically tailor information in that way. So they're going to have to, in every case, research existing documents to cull out the mandatorily narrowed requested information and create a new document that provides that. So you're in a requester is in a catch-22. I make my request too broad, it's denied because it's not mandatorily limited. And if I limit it the way it's supposed to be, it's denied because now somebody else needs to do the research, the custodian needs to do the research to call out that narrowed request. I think it's a disastrous provision that will only lead to litigation. And in addition, some of the standards within it are overly vague, like what is a reasonable time frame? What is a limited subject matter? For that reason alone, although that's clearly not the only reason, I very much object to this bill. I think it is destined to create endless litigation and free access to government records, and I ask you to stop it today. Thank you.
Thank you for your testimony.
Good afternoon, committee members. I'm Evelyn Murphy, co-president of the League of Women Voters of Monmouth County. I'm here today at the request of my board of directors, representing 320 Monmouth and Ocean County members living in legislative districts 9, 10, 11, 12, 13, and 30, who remain vehemently opposed to the attempts to roll back the Open Public Records Act, gutting important provisions that we rely on every day as League members. The amendments to the bill were unofficially released through the press just this week. This disregarded our calls for more time for the public to properly evaluate the contents of the legislation. Even with limited time to review the amendments, however, we can see that many problematic provisions remain, sort of wolves in sheep clothing. You changed the language, but you did not address the core issues. Specifically, changes to the fee shifting, as we've heard, still make it difficult for the public to be able to find legal representation. Changes to the harassment provisions still enable the public to be sued for vague and unclear reasons. These provisions are already hampering us because when we need to ask for things from local municipalities, we're already censoring ourselves. Are we asking it in the right way? Is someone going to be denying us under this law that's being proposed? And so do I dare submit a request on behalf of the League of Women Voters, which might then lose its authority to request documents at all? Or do I say, well, I'm old enough, so I probably am not going to do this much longer. I do it as a person instead of as a league. Those are things that are occupying our minds already. And with this change, it's going to really have a detrimental effect on our ability to represent voters. And then it still remains difficult under the provisions of this bill, as Janie has indicated, for people to access the records they need. So I'm here to please ask you to listen to the voters and vote no on this bill once and for all.
Thank you for your testimony.
Chairwoman, I just have a quick question. So your testimony is that asking for having a very specific topic as well as asking for a very specific time frame is unreasonable?
I think the part of that provision that's the most concerning to me is the sentence after, which says that a custodian of records can then reject the request because it requires research and the collection of documents. So it seems like the provision is trying to do two things that are mutually exclusive. Saying, ask for a very specific manner, but records aren't created in that kind of manner. You don't create emails that only address one narrow subject, or you don't only address a subject in a certain time period. So to get the right information responsive to the request, now instead of the journalist who gets a mess load of emails to do the research and find what's important, the custodian of records has to do that research. But under this rule, if the custodian of records has to do that research, they can say, I don't need to comply with this because they provide community research. So I'm not completely opposed to some limitation on the means that the request has to be made. You can't just say, I want every email, every written, on every topic forever, but you can do a reasonable time frame and a reasonable limitation. And then the custodian has to do their job and find those documents and give it, not say, well, that means I need to look through them and see, does this email address this? Oh, only page one of it does. Now I'm creating new documents, I'm doing research. I don't have to do that under this rule. Go away. That's the problem I have. Thank you.
Thank you. Assemblyman Law?
Thank you, Chairwoman. Thank you for your testimony. I'm kind of looking at this where we're sitting here trying to make adjustments to this bill so that it's more palatable to you. And that's one way to look at it. I'm kind of looking at it like, why don't we keep the bill in force and just make certain changes, moderate changes to it that will just address the couple issues that aren't working properly and leave the rest of it intact. So, maybe I'm a contrarian, but it seems to me that we should be looking at it that way. Now, I spoke with several of my colleagues before this meeting, and one of my colleagues mentioned to me an issue that I was hoping you might be able to help me figure out. My constituents always know more than I do. The colleague said to me, he was a former mayor, he said that we had gadflies who come in that basically harass the clerks with on and on and on every single day, with every hour, with more open requests. And somebody asked for something, they printed out 900 pages, and he came and took it and dumped it in the garbage, right in front of the clerk, just to poke him in the eye. So these types of things are concerns for municipalities. Municipalities that are small. One of my other colleagues said, well, the entire municipality is 2,500 people. They can't afford to cover all these costs. It goes into the hundreds of thousands of dollars. So help me to support you. How do we address some of these things? What would your ideas be to amend the bill to address this, and then, or just put the bill aside and come in with another piece of legislation that would address those things and leave OPRA intact? What would your answer be to me and my colleagues here? Because we're all searching for something, because I think many of us are vexed on this committee today about how we're going to vote.
I think the first step of that would be to not be rushing this process. And the fact that we're here on a Friday, which is uncharacteristic to be debating this for one particular bill. But I think you make a reasonable point that there is room for improvement, and those conversations have to happen and need to continue to happen. And for the overhaul, for something this large to be happening so fast, and I understand that there's been work for at least a year on trying to get this, and there's been multiple introductions of this bill, but it's just disingenuous for any assumption for it to be that we've gotten to this point because the public has been engaged and absolutely on the same page with the sponsors. It's just not that true. There's still a great debate to be had. And I think to speak to your point about arbitrary OPRA requests and files, I think Senator Weinberg puts it best when the public are annoying. That's what they do. Whether we like it or not, you're a public servant. Officers of agencies and administrations are public servants, and It's not our place if something seems arbitrary, if it's within their right under the law. The public are annoying for a reason, and sometimes that annoyance or that nuisance is to make sure that we're doing what we're supposed to do as a government.
If I could just add one thing, I do agree with the approach of, leave open intact and try to figure out what the most vexing issues are and address them in narrower forms of legislation that need to be worked on, again, not on a Friday afternoon in front of a mic on the spot. However, I will say I previously practiced in family law, and there were issues of repeat offender litigants who would just come to court filing frivolous motions after frivolous motions after frivolous motions. It happens in every area of the law, some more than others, and it is vexing and it is a problem. But they didn't write legislation that said you can no longer have the right to go to court over these issues. You can be thrown out. What they did was take it on a case-by-case basis. So if a judge saw a repeat offender over a long enough period of time, they could, put in place remedies that address just that person. So I'm envisioning, and again, on the spot, I don't know exactly what the language would be, but there could be a way where if a person has gone to court repeatedly, they've been denied records because it is overly burdensome or some way that it would be drafted, and there's a repeat offender kind of provision where judges might have discretion to deal with that issue on a one-person basis, not changing the accessibility of government records to the entire public. So it would take some thought to figure out exactly how to write that, and that's what needs to be done. Take some thought.
Thank you.
So, through you, the chairwoman, just one.
I was just going to suggest perhaps you meet with the sponsor of the bill. If you have some questions or suggestions. Did you have any other questions?
No, that's fine. I'll take your counsel on that. Thank you.
Okay. All right. Thank you all for your testimony. Thank you. Next, we have Scott Campbell from NASW and Jacob Kaplan from, is this Horizons, New Jersey?
Access.
Oh, Access, sorry. Who would like to start?
Hello, committee. Thank you for allowing me to speak. I'm going to start out by saying the best way to protect OPRA is to protect personal information first. Can you hear me? No, I can't hear myself. Okay. So in order to do that, I have 3 amendments. The first amendment, I'm asking you to strike out PI and insert PII. In other words, you got a definition in the bill that says personal identifiable information, but it doesn't match the bill because everywhere else it says personal information. It's a whole other. So if you can insert where it says personal information, personal identifiable information, then those two are linked, they're synchronized and everything. This amendment, the second one I have, is persons fulfilling an open request for custodian need to redact all PII or all personal identifiable information and names and police records. We live in new times now. I'm going to just give you a quick statement on that second amendment line. We live in new times now. Police blocks traditionally release our names. We hit a deer. Everybody in the neighborhood knows. Yeah, that's okay for a newspaper, but the whole world, even the Middle East, we're supposed to tell them, parents' names. This bill will protect that way it is. Protect technically the personal identifier. But what I'm asking, and then there's another statement I have with my second amendment. With my second amendment, you go on the internet now, you put sobriety tests. Right now, you can put in your sobriety test, you can see a load of like 1 years of people who's been pulled over for sobriety tests and refuse to take the test. who've not been guilty. I don't think we should be disparaging New Jerseyans the way it is now. Hey, you could put that in there and see a whole year of, I think it's Middlesex County, everybody got pulled over. Do you want your kids on their iPhone saying, hey, your mommy and daddy got pulled over? Is that the world we want to live in? So that's why I'm leading to my amendment. Again, my second one, the amendment to, eliminate names. Now, let me go on to my third. My third is, you put a pair of teeth on this bill for penalties, but it only seems to be towards the public. I think we need to have custodians just as liable if we were to protect all this personal information and names, that they knowingly, I guess the amendment would be, have them a cover entity to the penalty, saying if they knowingly.
If you could finish up, that's time.
Thank you. If they knowingly release that, that they are subject to the same fines in the penalty. And just real quick for everybody else, I hear the same thing. Really, the words of perception, obviously reasonable, need to be striked out. One person's reasonable is another person's definition of reasonable. And we can't say everybody's synchronized on the same thought. So I'm just doing that for the favor for everybody, and I will thank you very much. I ask you to please vote in favor of the bill, because I know you can make modifications and more readings. Thank you.
Thank you for your testimony. Next.
Excuse me, sorry. Hi, my name is Jacob Kaplan. I am the Director of Government Affairs and Advocacy for Access New Jersey. We are a statewide nonprofit membership association of 40 agencies that provide workforce training and development services for individuals with disabilities. Another role that our organization has is the central nonprofit agency for the State Disability Set-Aside Program. This is an effort through state contracting for goods and services to employ people with disabilities of all types. And last year, this program employed nearly 1,800 individuals who worked more than 650,000 man hours, earning an average wage of $16.45 an hour. And part of what our organization has to do is find out what government entities are purchasing what goods and services and at what price and from whom, so that we can have those contracts set aside to employ people with disabilities when appropriate. And by very nature, our requests are commercial in purpose. And the amendments that were discussed yesterday in the Budget and Appropriations Committee did include a carve-out for nonprofit organizations to not be included in the commercial purposes language. So we appreciate that language and encourage the Assembly to ensure that that language makes it into the final version of the bill that is eventually going to be voted on as well. And then another thing is there may be room for additional clarity on what can be considered harassment to filing multiple requests, so that employment opportunities for individuals with disabilities and other set-aside programs that the state of New Jersey has, including those for groups like disabled veterans, LGBTQ+ businesses, minority-owned businesses and the like, aren't unintentionally impacted when they use the OPRA system to try and find opportunities to fund jobs and business for their communities. So those are the two main points that Access wants to make, and we just encourage that to be included in this bill if it is to move forward, so that we don't have unintended negative consequences. I'm happy to answer any questions here or later on about the program or about how this legislation could potentially impact. Thank you.
Thank you for your testimony. All right. Next up, we have Doug O'Malley, Environment New Jersey. Charlie Cravenel from Food and Water Watch. Talani Taylor, also Clean Water. And Molly Cleary, also from Clean Water. All right, who would like
Good afternoon, members of the committee. My name is Charlie Cradaville. I'm the Central Jersey organizer at Food and Water Watch, and today I'm testifying on behalf of our 70,000 members around the state. And I'm here to say this is not legislation, this is an abomination. This bill gives expansive new excuses for agencies to delay and deny requests for records. It guts the existing enforcement mechanism that holds agencies accountable. And it specifically empowers government agencies to sue their own citizens. This is unacceptable. At Food and Water Watch, we use the OPRA to learn about dirty, polluting projects and to stop them. Our members are smart, the decision makers are smart, and we need the facts to be able to stop these dirty, polluting projects. And OPRA is the main way that we get reliable information on what is being proposed for our communities. We agree with Mike Davis, the law needs to be changed in ways that expand public access to public records and increase the efficiency of the process. Instead, the proposal before you today introduces new obstacles, more restrictions, and creates new rights for the dreaded commercial requesters. I'll draw your attention to an OPRA request that I made in April of 2020 of the BPU. It was request number W158232, and it set my own personal record for the longest response time. My request was ultimately denied for being overbroad more than 26 months after I filed it. It was a request seeking information about people's water being shut off and the pandemic policies that were going into place to protect people from having their water shut off. That denial came through on June 29th, 2022, a couple years into the pandemic. Obviously, the current system needs to be more efficient and improved, and this does the opposite. This bill does nothing to improve access to records for the residents in New Jersey. It creates new rights for corporations and new powers for the government to drag New Jerseyans to court and take their access rights away. And I also have to note, I think it's telling that none of the sponsors or co-sponsors of the bill came here today to back their own bill. Tried to have dialogue with Assemblyman Danielson, who's my representative, and he hasn't answered a single question. He hasn't spoken on the record here to this committee, and I think, the hearings in the Senate revealed that the prime sponsor there either hadn't read or didn't understand the bill and its impacts. I'll just say we need you all to take a step back, talk to the advocates, learn about the OPRA, and put the brakes on this terrible idea, and I'd be happy to take any questions you have.
Thank you for your testimony.
Hello, good afternoon. My name is Molly Cleary. I'm the environmental advocate at Clean Water Action. I would like to thank the chair and the committee for the ability to speak on this bill today. Clean Water Action, as an organization, stands for people, action, and justice. It was integral in the creation of the 2020 Environmental Justice Law. To ensure this law is properly enforced and to give those in the EJ communities to ensure this law is properly enforced and to give those in EJ communities the necessary information that they need to ensure that this bill is properly enforced, our EJ organizer ex-Braithwaite uses OPRA every single day. With the new amendments, including the redaction practices, there are no guardrails. When there are no guardrails, crucial points of information can be redacted and continue harm to these overburdened communities. We can also see that there are $8 million appropriated in this bill. This is money that can be used to create more jobs in the custodial departments where there's overburden. I was in the Senate yesterday. I heard the testimony of these custodians of OPRA. I heard their pleas for help. And that help can be done by using our budget, which is based in values. The budget is a value-based document. We can use those values to help these custodians of OPRA and ensure that they have the help that they need by creating more jobs and reappropriating the money to where it's needed to continue to open and use the Open Records Act. Thank you.
representing Clean Water Action. I currently serve as the Zero Emissions and Warehouse Organizer, and I'm here today to urge you to vote no on this bill, which would make it much more difficult for the public to access public records. As the Zero Emissions and Warehouse Organizer, I see this bill in its current state as being extremely problematic, especially for the communities around New Jersey that are being impacted by the growing warehouse development. Having access to public records like warehouse applications is essential so that communities can advocate for themselves against unwanted development, which can cause a myriad of problems, like increased traffic congestion, disruption in natural habitats, and an increase in air pollution from diesel trucks. This bill would only benefit the developers themselves, as they would not be held accountable for their actions, and ultimately be given a pass for keeping impacted communities in the dark about how their development plans would impact them. The people have a right to access to such information, and this bill would only diminish that right. Thank you for hearing my testimony, and again, I urge you to vote no on this bill in order to protect OPRA. Thank you.
Thank you for your testimony. Thank you. Next, we have Jim Sullivan from the ACLU of New Jersey, Trevor Conroy from People's Organization for Progress, Marcella Samaderis. Okay, thank you. From POP, and then David Krinkle from Power New Jersey. Who would like to start?
Good afternoon. My name is Jim Sullivan, and I am the Deputy Policy Director for the ACLU of New Jersey. Thank you for the opportunity to testify today in opposition of A4045, which would decrease access to public records by making numerous changes to the Open Public Records Act. First, let me be clear. The ACLU New Jersey is vehemently opposed to this bill, despite what some lawmakers have said. We did engage in meetings to convince legislators to stop this bill or to make major changes that would increase transparency, not limit it. It's clear now that both houses did not take our concerns seriously. This piece of legislation is another example of the perverse view of transparency many lawmakers hold. In 2023, this legislature passed the Election Transparency Act, which, despite what they may have you believe, decreased transparency into money in politics. A4045 decreases transparency in public records. Without government transparency, there could be no accountability or public trust. New Jersey deserves all three. ACLU New Jersey opposes this bill because of the negative impact it will have on public access to public records, government transparency, public trust in government, and the ability of New Jerseyans to hold their government accountable. Both the contents of this bill and the process by which it has been developed indicate that this legislator is willing to decimate these core democratic features that keep government and government actors accountable. We have several specific concerns with the current language of this bill that must be addressed. First, the removal of mandatory fee shifting in Section 7 of this legislation will effectively remove the only mechanism in place to enforce the provisions of the Open Public Records Act. Under current laws, pro bono attorneys can take OPRA cases with the understanding that they will only get paid if they win. The changes in this legislation make it so attorneys would have to take the cases with the understanding they might not get paid even if they do win. It sets up a system that all but guarantees no attorneys will represent requesters that have had their request wrongfully denied. We also have serious concerns about language in Section 8, which allows for government agencies to sue requesters for seeking records with the intent to substantially impair the performance of government function. Substantially impairs a vague and undefined standard. Government agencies could readily weaponize it to retaliate against requesters and chill legitimate requests. Providing government agencies with this tool will discourage OPRA requests, as people will be concerned that they may be sued over making a request. Additionally, this bill makes significant changes to the way in which fees for processing OPRA requests are challenged under the Open Public Records Act. Under current law, government agencies have the burden to prove that the fees or service charges they impose are reasonable. The currently drafted language in this bill would shift the burden onto the requester to prove that the fee is unreasonable. This is an unnecessary shift, as the government agency is best positioned to explain to the court why their fees were reasonable and controls access to all the evidence that bears on that question. Furthermore, the ACLU New Jersey is incredibly disappointed to see that the legislature is not willing to provide more access to police disciplinary records through
That's time if you can finish
I'm
your.
wrapping up. Instead, proposing and then fully striking a provision creating a police records task force. New Jersey is behind more than half of the other states in the country when it comes to police disciplinary records, and the decades-long fight for transparency deserves substantial action rather than political theater. It's hard to accept that this bill is open reform when all it does is limit access while not increasing access in any meaningful way. Overall, the ACLU New Jersey is disappointed both in the content of this bill and the process by which it is moving. It is undemocratic and a slap in the face to New Jerseyans across the state. Thank you.
Thank you for your testimony.
My name is Trevor Connor. I work in the People's Organization for Progress. I'll begin by reading a letter from the People's Organization for Progress. Dear Assemblywoman Lisa Swain, Chair, and Assemblywoman Marlena Reynolds Jackson, Vice Chair of the Assembly Appropriations Committee, and other members of the 221st New Jersey Legislature. The People's Organization for Progress, or POP, is a long-standing grassroots organization fighting for racial, social, economic justice, and peace. And we oppose A4045 and say vote no, the way in which it is currently written. This bill undermines our democratic right to have governmental transparency in providing access to public records. We do not want any of the provisions of the Open Public Records Act, OPRA, gutted, given the current state of affairs. We deem this legislation extremely undemocratic and flawed, putting additional financial burdens on people wanting to access public records, given the continued overwhelming financial burdens on individuals and community groups superimposed by the pandemic added to the everyday monetary challenges this world additionally impact individuals appealing improper record requests. Continued transparency and accountability to which we are all entitled. Instead of directly challenging our democratic right to access public records, i.e. police brutality, video recordings, and other records tied to police misconduct, the other entities that are expected to be accountable to the citizens of New Jersey, we'd expect you to only support the process where the public interests are at the forefront. POP is always open to improving systems, but not at the public expense where it undermines the very fabric of democracy. Given the many tenets of our governmental agencies, we are responsible for meeting the fundamental needs of its citizens, including but not limited to transparency and accountability. We would encourage New Jersey to establish a Sunshine Law Commission, in which process we would expect participation in its development to include not only legislators, but large community representation to ensure the concerns and needs greatly represented. To wrap up my time, I speak as a New Jersey student and co-chair of the People's Organization for Progress Youth Committee. The youth of today are more politically conscious than any other generation of youth. This is due to our access to information being unprecedented amongst youth of previous generations. Access to public information is integral to maintaining democracy, and any attempt to restrict government transparency is a step towards fascism that does not go unnoticed by young voters. To put it simply, if you vote against the interests of your constituents, we will vote you out. All powers to the people, Chuck E. Overhaul.
That's his first time testifying in the State House. You did a great job. Thank you. My name is Marcella Sinaderis. I'm an educator and a mom. I live in Montclair. I've been employed by Patterson Public Schools since September 2000. And I'm very passionate about my children and my students, and I use OPRA to protect them. Through my work with POP, we created a whole database, and we're able to actually account for some of the derelict practices that goes on in our state education agency, to the point where I was able to write an article calling them derelict, and they really can't do anything about it because that's the case. And OPRA helps me be able to archive that information. And just to give an example, because I know there's this amendment about specificity. So I have this email correspondence with the OPRA custodian at, I just left, for the DOE with regards to, because in Montclair it became apparent that they were throwing kids at closets at Bullock School and Montclair Public Schools, mostly actually black little boys. They were throwing them into closets, padded closets. So I had over the request read like this: all usage reports for restraint and seclusion submitted by Montclair School District, because finally the DOE was supposed to be monitoring it, because for years, because I know a 25-year-old that was being thrown in that closet. I know someone who's 25 when he was little was getting thrown in that closet. But anyway, they supposedly started monitoring it. So I put in the OPRA request for the usage report, right? And then the custodian wrote me back and she was like, Ms. Semideris, we are in receipt of your request below. Could you please clarify what you mean by usage reports so that we may continue to process your request? So I respond, the reports that indicate when children have been put into seclusion closets or restraint. And then I got that denied, not made or maintained. Now, there shouldn't be any privacy issues with that, because anytime that I've offered something that had other people's personal information, the names would be redacted. So there's no reason why anybody in the state should be withheld the information on when kids are getting put into padded closets. Because we know what happened, and that people were actually just throwing them in there when kids weren't not compliant, not just when, because supposedly you have those closets because the child becomes so dangerous, can hurt themselves or hurt somebody else. That's supposedly why they're needed, which I don't agree with. But anyway, given that, these kids were actually just being thrown into that closet because they weren't compliant with directions. So this is where we're going with it, and I just want everybody in this room to know, other organizations, I'm willing to help mobilize. The county line is gone.
That's time if you could wrap it up.
Okay, so I just want everybody to know, I'm so committed to this right now. I will drop everything and make sure I come for anybody who votes against transparency. Thank you.
Thank you for your time.
Thank you, Madam Chair. Thank you, Madam Chair. David Pringle. I'm representing Empower New Jersey, the state's largest climate coalition of over 100 community, faith, labor, and other groups focused on securing a thriving, squeaky clean, truly green economy to alleviate the current climate emergency, promote justice and public health, and create better jobs than our burning, dependent economy that's literally killing people and destroying properties. A strong OPRA is critical to that effort. And thus we strongly oppose this bill and the amendments by the legislature circulating this week, including those voted on yesterday. We do not oppose reform. In fact, we support, one, the reporting, which we're confident will show concerns about excessive litigation are overblown that are currently in the bill, and also appropriate modernization and restricting of commercialization, both of which are not in this bill, despite those supposedly being key motives for the bill. Senator Sarlo acknowledged the real motive behind this bill, fee shifting at yesterday's hearing, and that's the linchpin to our opposition. This bill is opaque, it is not transparent. It will reduce transparency and undermine good public policy across the board with more denials, yet less litigation. The deck is already stacked against the public. One, government defense lawyers always get paid hourly, whatever the result. If anything, they have an incentive to overbill and litigate more. Two, the public plaintiff counsel only gets paid if they win. Contingency, if they lose, they don't get paid. They're out of luck. They get nothing. In fact, that's real risk versus no risk. Three, the courts have authority to make losing plaintiffs pay, punish frivolous lawsuits, and ensure payouts are reasonable, and regularly reduce winning plaintiffs' attorney's fees and billable hours and hourly rate in calculating the payouts. And four, again, they only get paid when government breaks the law and the public proves it. All of that is neither exorbitant or excessive. Why is this happening? If government wants to reduce attorney's fees, here's a few ideas. Don't break the law. Don't deny the request. Reduce pay to play. Or how about this? Reduce the rates you pay your government lawyers. We're also very concerned about how these amendments in the process has been portrayed by some legislators. These are not our amendments. This is an action working families, League of Women Voters, ACLU. There has not been negotiations between us and legislators, representatives. One-way dialogue is not negotiation. You can disagree with our position, even think it's unreasonable, All that's fair game and debatable, but you cannot mischaracterize it or us. And fee shifting is a core line in the sand. It's like you have a cake, it's like your kid's caught with your hands in the cookie jar. Denying it, even with your hands still in the cookie jar. That makes Trump proud. We live in troubled times. January 6th insurrection, Canadian election denial, indicted former president and New Jersey U.S. Senator, Ukraine, Palestine, Israel, U.S. college campus, Black Lives Matter, and so much more. U.S. Democrats, nationally, and never Trump Republicans are fighting for and love democracy.
That's right.
This bill and this process hates democracy. It's led by New Jersey Democrats. Is it worth it? Will you be rubber stamps? Don't shift the fee. A powerful, appropriate public check on government. Thank you.
Doug?
Thank you so much, Madam Chair, and apologies. As my father always said, better late than never. So, I'm Doug O'Malley, Director of Environment, New Jersey. I'm here I was going to say this morning, but again, I'm running late, this afternoon, for a very simple reason. We are joined by a broad coalition of not just democracy advocates, not just quote-unquote progressives, but people that care dearly about transparency in government, the ability for the public as a whole to be able to see what government is doing with public dollars. That's the reason why we got OPRA in the first place more than 20 years ago, and that was a bipartisan effort supported by Speaker Jack Collins. Assemblyman George Geis from South Jersey as well was a key leader in making sure that OPRA passed the Assembly, and of course the godfather of sunshine in New Jersey, Senator Byron Barrett. He had got the Sunshine Law passed, and then this was his final legacy. And if Byron Barrett was still here with us today, I can guarantee you he'd be fighting to ensure that we reformed OPRA but did not roll back public transparency. And that's what these amendments do. And I think that's really critical to understand is that, the amendments are supposed fixes, they're fatally flawed because they're still providing the opportunity for optional transparency. And if sunlight is truly the best disinfectant, the problem is if you make it optional, you'll suddenly find yourself in the darkness. And I wanted to use a very specific example for another issue that's in front of the legislature right now, and that's the crisis in New Jersey transit. Because of OPRA, the press was able to get a copy of the contract with North Highlands, which is spending $6 million to help to figure out what happens if New Jersey Transit does not get the funding it needs. Without having the ability of accountability, not just for the public but also for the press, stories like that aren't getting told. And I don't need to tell everybody at the rostrum, right? Democracy depends upon this transparency. I wanted to specifically to reference a few amendments that are especially concerning. Fee shifting, you've heard ad nauseum, but in terms of the agencies, and this is very concerning, the bill as it stands with the amendments allows government agencies to sue requesters for seeking records with the intent to substantially impair performance of government functions. Please tell me how we define substantially impaired, because that is literally transparency in the eye of the beholder. It's in the eye of the agency. That is an incredibly dangerous language because it's vague, it's an undefined standard, and government agencies could literally weaponize that to say that everything substantially impairs them. Second, creating a rebuttable presumption that service charges for OPRA requests are reasonable. The bill right now shifts the burden on the requester to prove a fee from the agency for fulfilling an OPRA request is unreasonable. So I'll wrap up with the last moment and the last item is the level of specificity required in the request basically ensures the only way that you can put in an OPRA request is if you know what you're looking for. And that obviously, the whole reason to have OPRA is to provide sunshine, not to encourage less transparency. Thank you.
Thank you for your testimony.
And that was the point I was trying to make. I don't think that was clear. That record exists, but I wasn't specific enough. But I left that at that point. So please understand, and please don't have this bill. Our children need transparency. Our future needs transparency.
To the last gentleman who just gave this.
Wait, Assemblyman, you have a question?
Yes.
Oh, okay. For Doug O'Malley.
I noticed you were going through a litany of things that you thought needed to be corrected in the bill. Mr. O'Malley?
Yes, that's
I wanted to discuss one that you didn't get a chance to discuss or neglected to consider. I'm concerned about the anonymous requests being eliminated from the bill. We have a society, especially with the advent of social media, that feels empowered to bully people. I've seen it in elections. I'm witnessing it right now in a local election. Personally, I think that that's a problem in this bill. What's your opinion on that?
I'll just speak personally, and then I'll obviously defer to the many organizations that are focused on OPRA. We do live in a different world right now, a world that provides doxing. Obviously, you do want to have more transparency to know who's asking for records, but in a world that there can be negative repercussions for asking for information, there should be an ability for people to say, I would like to see this information, but I'm worried about potential repercussions if I release the name. So that is a concern. I'm glad you brought that up, Assemblyman, and I'm sure some of the other advocates would be happy to speak to that point as well.
Thank you, Chair. Appreciate it.
Thank you. All right. Next up, we have Bruce Rosen, Betsy Cross, Frank Richard, Kyler, Denise, and trustee of New Jersey State Constitutional Trust. There's no name on this one.
Can you hear me? My name is
You have to put your microphone on to speak, please. Thank you.
My name is Bruce Rosen. I'm a media lawyer for 35 years with several firms, and I teach at Rutgers Law School media law. And I want to make a point about the media, but first I want to make a point about when I was coming in this morning, there's a security guard. I started talking about I was here for the OPRA matter, and he starts telling me about he's trying to get copies of an easement, and he can't. It's just impossible to give him such a hard time, and he's going to have to find a lawyer. And I thought to myself, how impossible is it going to be for him to find a lawyer if there's no guarantee that at the end of a successful road, there is a way to get paid? It is important, and Assemblyman Roth knows, because I was in front of a panel not a year ago to talk about anti-SLAPP, and the Assembly and Senate unanimously, and the government signed a bill that prohibited SLAPP suits, strategic lawsuits against public participation, and it put in there that these fees shall be paid when you prove that. So a judge has to determine in those cases whether the case is a matter of public concern and if there's a problem with the complaint, just as a judge here has to make a determination that there was a prevailing party and that the fees should apply and what those fees are. I'm not arguing for the $1,000 or $800 or whatever Senator Sarlo was complaining about yesterday. What I'm here is there is no way that there can be an organized bar to proceed for OPRA suits. Maybe that's the design of this bill, to end the 4 or 5 or 6 or 10 lawyers who actually do this work. But what this will do will end that, because there's no financial incentive, there's no way that they can maintain a practice. If that is the case, if there is no way that they are guaranteed, if they win, that they would receive these funds. And the other thing is that the media is in such a turmoil, in such a bad situation, that it's not going to be a way for the media to afford attorneys to pursue this. So, you can get paid hourly for advising the media how to phrase an OPRA request. They pretty much know how to do that. Now, They won't know how to do that later. There's no way to search for a needle in a haystack where you have some smoke looking for the fire, if indeed you have to know exactly what you're looking for. There are so many things that are wrong with this bill. There needs to be a step back and a discussion. And sending it on, I don't know what you can, waiting to talk to the sponsor, with all due respect, Ms. Chairwoman, is not the answer, because this thing is coming up on Monday. This is like a
time, if you could wrap it up, please.
Thank you.
Okay, thank you for your testimony. Who would like to go next? Okay.
Hello, my name is Frank Richard. I am here in two capacities. Primarily right now, I'm speaking, as you called me, for the New Jersey State Constitutional Trust, as a trustee of such. As a trustee of such, I am here in special appearance and will hold you to the oaths that you have taken. I will speak in only fact. You cannot vote yes on this and obey your oath to the New Jersey State Constitution. And I am here to tell you why. Article 1, paragraph 2, paragraph 6, paragraph 18, Article 3, paragraph 1, Article 4, section 4, paragraph 6, section 7, paragraph 3, Article 4, section 8, paragraph 1. I don't see you guys have pens out. You don't have pens taking this down. I'm telling you guys how if you vote yes, you will be violating an oath that you took.
Could you just lower your tone a little bit? You're yelling.
Yes, I can lower my tone. I choose not to. I am enraged by what is going on here. You are violating your oath to the Constitution for New Jersey if you vote yes. I just gave you the reasons. You're not even curious. Are you guys all experts on this Constitution you've taken an oath to? I presume you are, because I see no questions or interrogatory looks on your faces. But you took an oath to this Constitution. This is a copy of a certified copy, just gotten up the road. And talk about open public records. This is the Constitution as amended for 1947. And you know how hard it was for me to get this? Get a certified copy from archives? You know how much I had to pay to get this? But that's besides the point. What is the point here is if you vote yes, I will go through these sections. Because you didn't write it down, you're not going to take a look at it later. Get real. You guys held this special meeting on Friday for special interests. What's going on here right now? Why all these people are here? Remember when this was up, when A 4045 was up a few months ago, and you kicked out so many people that came to speak? You kicked them out and you said, oh, we're not going to hear it today because there's too much. Well, no one's been brought to the table to hear their concerns. I see that look on your face. Go ahead, what are you going to say? What are you going to say?
That your time is up.
Yeah, and I don't accept. I don't accept, and here we go.
Your time is up.
No, I do not accept.
Out of respect for everyone else who would like to testify, I announced at the beginning that everyone.
I told you I did not accept black men. Raise my hand. I did not accept your contract.
You're in the Appropriations
Every
Committee.
person may speak, freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that right.
Stop speaking and let the other people speak. You are violating their right to testify in this committee.
Did you solicit my consent for this 3-minute limit? And where is the rules? Where is that in writing? Is that operable, this policy? Is it a writing? Can I receive that? But no, I have the New Jersey State Constitution in front of me where it says, every person may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that right. I am not abusing this right. I am not harming anyone. In fact, if you vote yes, you are harming and you are trespassing against the public. You are here today with a bill that's been proposed by municipalities, by a bill that's been proposed by mayors. What are you trying to hide? Are you committing a crime? Are you funding genocide in Palestine? I don't know what's going on this time. You turned off my mic, but I can still recite.
Cross,
I am pleased.
Here, would like to testify, and she has a right to testify just as you do. Betsy, it's your time.
Do you mind if I continue?
Why are you pitting people against each other?
No, I'm not. Well, because I haven't agreed to this 3-minute limit. I didn't see that. I didn't see a rule for that before I traveled here. No, it is. It is. Because this is the root of what's wrong. This is the root of what's wrong with OPRA. And I refuse. In fact, I'm going on a hunger strike. Water and salt only until I'm heard.
Thank you for your testimony. Betsy?
That's across. I wish I had more notice for this meeting. I wish I could have gotten here yesterday, but I couldn't because I was picking up my son at college. I'm deeply upset that this is looking to be passed. I've been putting in for OPRAs for 12 years. I've had more and more OPRAs denied that never should have been denied. I find this whole thing so upsetting. And just, you know, what's happening. The attorneys that are working for the township and Board of Ed are only going to overbill, and they're going to litigate more. You're going to take this out on the taxpayers. We're not going to be able to get public information. We should be able to put in our own requests anonymously. I have written the Attorney General. I have written Kevin Walsh in the Controller's Office, Scott McDougall. I have written the Banking Insurance Department. Nobody gets back to you. Nobody cares. And well, I guess we'll find out today if you actually care. I've been targeted. My son has been targeted. They put my son's picture in an OPRA lawsuit. My OPRA attorney actually had to write to the judge to take his picture out of an OPRA lawsuit. He was a minor. The stuff that has gone on just Wall Township alone, I feel like I'm on an episode of Ozark. I feel like I'm funding corruption, and I don't want to be involved in it. I try my best to fight it. I have asked to meet with Senator Sarlo and anybody else. Ms. Swan, I would love to sit down with you. I find women are better, easier to talk to. I will share with you specifically Wall Township. We have a kid in the closet that's suing. Her lady from Montclair. We have the football scandal. We have had one scandal after the next. My first OPRA was for our superintendent's contract. His employment contract, he wouldn't give it. That was James Hill. He eventually went to jail. And it was because of my OPRA. I mean, what you're doing here is not going to work. It's not. You need, and I've offered to help you. You can look, we can go over my OPRAs, and you can say, yeah, this is not right. Brian Smythe, the only way that my attorney gets paid is when Brian Smythe breaks the law. He does it over and over and over again. And the diploma GIF is a bug right now. They're not following their own bylaws. So I've written Senator Sarlo today and a number of other people. I will forward the email to you. These people haven't met in 6 months. We're paying them over $1 million to be in the diploma GIF. And they are not doing their job.
Time if you could do that, please.
Yeah, so I will forward to you, and I can do it to everybody here, my documents. And I would love to meet with you. Thank you.
Thank you for your testimony. Okay. Oh, I'm sorry. Yes.
Thank you, Madam
Madam Chair, and good afternoon, committee members. My name is Kyla Deneen. I'm not here today representing any one group, although I've been involved with many in our state that have benefited from the important freedom of information rights that OPRA has successfully provided for more than 20 years without causing catastrophic damage to governmental operations. I would like to note that while I'm a lifelong New Jersey resident, this is the first time I've felt compelled enough to personally come to the State House to testify on a bill. I don't know why this proposal has come back up for consideration with such relatively minor differences since March, when we know that the April Fairleigh Dickinson poll found that 81% of registered voters in our state opposed changing OPRA. At a time when we are battling fake news and conspiracy theories, our government cannot afford to give its citizens reasons to believe that it's hiding things from them. I'd like to speak specifically on the under-discussed topic of metadata. This bill would allow records custodians to remove or scrub metadata from OPRA-provided files, limiting it only to that which, quote, identifies authorship, identity of editor, and time of change. By looking at this piece of paper in my hand, you'll be able to understand why limiting metadata in records provision is a problem. That's because while you can see the piece of paper in my hand, what you can't see is that on the digital version of this document, I added to its metadata, in plain English, the lyrics to the nursery rhyme, "Mary Had a Little Lamb." But because I added those lyrics outside of any authorship and date parameters, if someone were to OPRA this document, a records custodian could hide from that requester the lyrics that I hid inside its metadata, which was easy to do, by the way. This is to say that this bill as currently written would allow government officials to insert whatever hidden information they want inside of documents that are otherwise subject to release under OPRA. And not for nothing, if the selling point of this bill is that it would reduce the government's burden in fulfilling OPRA requests, suggesting that a records custodian would ever be expected to take time, and removing metadata is a time-consuming process, by the way, to remove data from a requested record. Well, that just doesn't hold up then, does it? Lastly, I find the section of this bill that empowers governmental entities to be able to take citizens to court for filing too many OPRA requests to be wholly unconscionable. If we're able to take out language from this bill restricting commercial data brokers, then certainly we can take out language that would ever give a private citizen reason to fear that their government would take legal action against them for asking to access public records that their tax dollars paid to produce. I implore you to table this bill and to discuss these critical issues further, and I thank you very much for your time and consideration.
Thank you. Thank you for your time.
I am now speaking as Frank Richard. You called two people to, I need representation as well. I'm here presenting myself.
Excuse me, what? Is it
Point of order.
Point of order?
I think everyone had 3 minutes.
3 minutes is correct. And
Yes, that was given to the trustee of the New Jersey State Constitutional Trust. Now I'm Frank Richard, free man, man of God, occupant of the office of man.
you are...
Do you understand that?
You are one person and you had your...
No, I am not one person. You claim I'm one person. I am not one person. Can you please prove that to me that I'm one person? I'm acting in dual capacity. And why do I have to go? Why? Why do I have to do that? But what, for what reason? What did I do wrong? This is the New Jersey State Constitution, and it says right there, look, every person may freely speak. Now you're giving me the opportunity. What's your name and badge number?
I'm giving you the opportunity.
Okay, if you tell me your name and badge number, who's ordering me that? So like, you will be ordering me to do something?
You got about 5 seconds.
But I'm asking.
Carry you out of here.
Why are you going to carry me out? I'm just asking a question. Can you just give me your name and badge number? Can you take your hands off of me? Go ahead, tell me. No, your name and badge number. Names and badge numbers. Go, hands off. Hands off, names and badge numbers. Hands off, names and badge numbers. Hands off, names and badge numbers.
All the information I have.
Hands off, badge numbers.
White from the New Jersey Municipal Clerks Association, and Mike Sturr, Mayor. Oh, we have two mayors, Ray Heck and Mayor Muir. Who would like to start?
Madam Chair,
You're on.
I was on list, I'm only going to speak for 30 seconds. Mike Serra, Executive Director of the State League Municipalities. For the record, Lori Buckaloo, our Deputy Executive Director, is joining John Donadio later to go over comments regarding the amendment specifically. I'm really here just to introduce the mayors. If I can make one editorial comment, because I can't help myself sometimes. There have been comments here today about the process being rushed, and we're here on a Friday. Now, I've been at this 27 years. I was hired 12. But 27 years, I've been here on Fridays before. I've been here on Saturdays. I've been here till midnight. I was here on the 4th of July. This is the fourth hearing. The fourth hearing for the OPRA package. So, Yogi Berra once said that how long a minute is depends on which side of the bathroom door you're on. To those in local government, this doesn't feel rushed at all. My deep appreciation to the
not signed up to speak. A lot of us have signed up to speak.
Yeah, I've signed up to speak, sir. Thanks.
He's on the list. Thank you. Continue, please.
On behalf of the league, I do want to thank the sponsors, Assemblyman Anderson, Assemblywoman Flynn. Thank you to the staff. I know Seth Hahn and Tim Wyden put in extra hours working on the amendments, some of which may go a little further than we wanted, but we support this bill, and we deeply appreciate the efforts. I'm joined here today by Mayors Ray Heck, immediate past president of the league, and Paul Muir, who is currently the president of the Conference of Mayors, to offer a mayor's perspective on this. So once again, our thanks, and if I may, I'll pass it to the mayor. Thank you.
Thank you for your testimony.
Thank you, Madam Chair. I'll be brief, because to be emphatically honest, I've been listening to everything going back and forth, and a lot of stuff's been addressed.
If you could just state your name, please,
Yes,
for the record.
Raymond Heck, and Mayor Millstone Borough, immediate past president of the League of Municipalities. We were talking about 22 years this OPRA's been out. I've been a mayor for 17 years, actually on 18. I take a look around and I see on the other side of the world many of my distinguished colleagues that were local officials before they got where they are today. So you understand where we're coming from. I hear the word transparency, and I'll be emphatic on it. Transparency means efficiency, means trust and honesty. The 564 municipalities, 191 of us are populations under 5,000, which means that the clerk is usually the person that's in charge of dealing with the OPRA request as a custodian record. Small government is transparent, and if there's any single person out there, municipality, first of all, I don't believe a single municipality would be non-transparent, it'd be an individual of anything. And that person should be targeted, okay, for any kind of nefarious activity, not us. I'm sick and tired of being stereotyped among the other mayors, the commissioners, the legislators, because I don't get paid to do my job. I do my job because I love doing my job. I do it for my family, I do it for my community, very small. And like I said, I'm listening to a lot of this testimony today, and we're not too far off. We all want transparency, we all want efficiency. The question is I deal with empirical data, whether it's going to be quantitative or qualitative. So if you're asking me, if you're telling me about transparency and all these things that are happening, show the proof. I can tell you right now, if someone comes to my office one day and said, I want an OPRA request form. Okay, no problem, I gave it to him. I said, fine, what are you looking for? I was looking for this. Give me 2 seconds. I walked over, I picked it up, I handed it to the lady. She's like, that's it? I said, yeah, all I got was this. I was like, but here's the form. And I explained to her how to do it. We believe in OPRA. We believe in having the transparency. We believe in efficiencies. But what we don't believe in is sometimes it gets to the point, it's adulterated to the point that it hurts us. I'm sitting next to an esteemed colleague over here who's a clerk who will be able to expound a little more on this. But the thing is, that individual, okay, can be held accountable for a very restricted time frame. I have a town of under 1,000 people. I've had my clerk one time have several OPRA requests that he had to deal with before he had to deal with elections that night, which had a permissible time frame too. So the thing is, when you're dealing with, as a clerk, and as also a custodian, they got a whole do of work they got to do. And sometimes it takes away. When we say we work for the people, we work for the people, not just the person. So when someone says that, we're taking away from them, I'm working for everybody. I'm trying to help you. But the thing is, sometimes those things feel restricted. And the other thing is the standards law. I know a lot of you are looking around and looking at me. Yes, I'm also a police officer. Been a police officer for 30 years. I'm also one of the high-ranking individuals with the state PBA. So I usually sit here on the other side, talk about other issues. But one issue that we have in common knowledge,
And that's your time, if you could wrap it up, please.
our big common knowledge is Daniel's law. And the thing is, the last thing we want to do is make sure that the records are safe, are secure and safe, that people like myself and our colleagues are not affected. And I can tell you, Daniel's law was made for a purpose. Thank you.
Thank you for your testimony.
Good afternoon. My name is Paul Muir, Mayor of Bethlehem Township in Hunterdon County and President of the New Jersey Conference of Mayors. I want to thank you for your time this afternoon and thank you for the time that you have already put into this bill. We do believe that there has been much discussion, and as was shared yesterday, it is a point of compromise. There are things that we would like to see taken further as mayors, and there are things that others have spoken on the other side that would like to see. So I appreciate that we're trying to find a point of compromise. And the point of that is we're all here for good government. I think as we shared some of the municipal officials before and even at the state level, and good government includes transparency. We're here to support transparency, but it also includes efficiency. And so some of these amendments really help us with those efficiency items and also provide some additional protections for our residents. So it provides our residents with privacy protections. It helps our municipal taxpayers against exorbitant attorney fees. It allows requesters to be sent to our website to save some time and have some efficiency with our clerks. And it allows for our offices to have less disruption. So in conclusion, government records remain available to the public. I believe the average citizen would not see any change in submitting their OPRA requests to us under the current amendments. And this modernization is reasonable. It helps our municipalities provide those records to the public. So I appreciate your support and consideration.
Thank you for your testimony, and thank you for being under time.
Thank you for granting me the opportunity to speak before you today. My name is Kimberly White, and I hold several crucial roles in East Hampton Township and Burlington County. Over my extensive career spanning 3 decades, I've served diligently and in various capacities, including the clerk, the township manager, the QPA, and the local registrar. Furthermore, I've had the privilege of leading as the president of the Burlington County Clerks Association for the past 12 years, and previously as the former president of the Municipal Clerks Association of New Jersey. Central to my responsibilities is the meticulous handling of OPRA public records requests in my office. Each request is vigorously reviewed and processed in strict accordance with the legal mandates. This entails ensuring accurate provision of requested information and making any necessary redactions that need to be made. It is important to note that the complexity of OPRA requests can vary significantly, offering and requiring input and review from other multiple departments within the municipality. To manage the workload efficiently, we've implemented an OPRA portal system called Next Request. They're based out of San Francisco, California. This platform allows requesters to submit their inquiries online, streamlining the process for workflow. Documents are uploaded by their respective departments and undergo accuracy and redactions, and then they're released. While the system incurs an annual cost of $7,000 to the taxpayers annually, it has removed the need for additional personnel. However, this influx has necessitated a shift in how we provide public records, with several hours nowadays dedicated behind closed doors to ensure compliance. As the records custodian, I have to review all of the police records that are coming out of the office. An important point to highlight is that significant portion of OPRA requests stem from commercial entities rather than my own residents, a trend that has reshaped our operational dynamics. I come before you today to recount a distressing episode that underscores the challenges inherited in a public records management. I became embroiled in a legal dispute over a OPRA request for a public document. Although the document contained all of the requested information, it was labeled differently by our outsourced payroll company, leading to allegations of a denial of access to a payroll record. This unfortunate situation incurred $13,000 in attorney fees, borne by my taxpayers because I lost the case, along with the additional annual expense of approximately $7,000 a year now to switch payroll providers due to that record. This experience underscores the significant repercussions that can stem from seemingly minor discrepancies. The current OPRA reform bill is not reinventing the wheel. Its requests have been sent to our state representatives since 2019 with the same needed reform. If a resident is looking for a record pertaining to the township, we are going to go out of our way to make sure that we can get that record. It's their document as a taxpayer. But when commercial entities, when the commercial entities are looking for those records, it prolongs everything. My taxpayers do not want to be put on our dog list, they don't want to comply, and they don't want to be on a newsletter. Thank you for your time.
Thank you for your testimony.
Thank you, Madam Chair.
Thank you. Next we have Tanine Howard, Stacy Berger from Housing and Community Development Network, and Peg Sell from SPAN Parent Advocacy Network.
Good afternoon, everyone. My name is Peg Kimsel. I am.
Wait, can we just have quiet so we can hear our witness? Thank you.
Thank you, Madam Chair. I am the policy director at SPAN Parent Advocacy Network. SPAN is an agency, a nonprofit that has worked to educate, empower, and engage parents across the spectrum in New Jersey for the last 35 years. For those of you that I've not met before. Our focus is on families at most risk due to disability, special health care need, under-resourced or involvement in systems across the state, child welfare, juvenile justice, human services, etc. So we get to touch a little bit of everybody. I have to tell you, I was really excited the first time I heard that OPRA was going to get a fix because it's been so difficult. And I'm not a lawyer, I don't have a big fancy policy shop, and I will certainly bow to my colleagues or friends in here that know the law a lot better than I do. What I do know is how difficult it is for parents to access public records, for families that don't have resources to access public records. And so I was like, oh great, we're going to have an improvement. I was horrified to find out that that was not the improvement. The improvement was an additional access or support for families. And you've heard it all before. The horror for a family to worry about if they're going to be able to afford legal resources to oppose an OPRA request is something they deal with all the time. They deal with it in special education, they deal with it in Medicaid and SSI and all kinds of other Department of Children and Families. So this is not new for them, the underrepresentation or not access. But to pile on for us is really hard. And I'm sorry, I have notes on my paper because I was not prepared. I was hoping that, as someone said, we have had 4 hearings. This is sausage making kind of at its worst because I think we've had 4 hearings. I'm not sure if people are listening though. When an FDU poll says 81% of folks are not in agreement with this, it's time to take a step back and try to work it out. Try to figure out some better fixes. Try to think about the constituency that you represent. I too have a very important role in East Hampton. I am a citizen of that township and a taxpayer, and I quite frankly don't want anybody speaking for everyone in East Hampton or all the taxpayers there, because I think that we have a lot of work to do yet on this bill, and I am really, really troubled to go back and tell families that we've not only not improved it, we've made your access even more difficult.
And that's your time, if you can wrap it up, please.
One quick thing, I am so disappointed. I am a government geek. I believe in the republic. I am so disappointed with the legislature as a whole because I expect you to be our gatekeepers. I expect you guys to protect our democracy and our accountability. And thank you for the opportunity.
Thank you for your testimony.
Good afternoon, I'm Stacey Berger. I'm the President and CEO of the Housing and Community Development Network of New Jersey. We're the statewide association of more than 270 nonprofit community development organizations, private sector lenders, and housing champions working to make sure that everyone has a safe, affordable place to call home. This bill will dramatically reduce our ability to do that. Many of you have worked with us. I was here for many, many hours, not that long ago, working with all of you to pass a really landmark housing bill that not everybody here supported, but everybody here worked to make as good as it could possibly be. Passing this bill out of this committee today will directly hamper our homelessness service providers' ability to do their jobs. Many of you call our office and ask for help for your constituents. Instead of being able to help them, we will have to be finding attorneys to both protect those service providers because they run the risk of being sued, and also to get lawyers for them to be able to get the records they need to do their jobs. I cannot implore you enough, please do not do this bill this way today. I am a little bit, you can talk to that. I've been doing this just a little bit longer than Mike Sarah, which is hard to believe, but true. I was part of the original group of people who wrote and drafted and passed the original Open Public Records Act 22 years ago. I sat in the room, I was part of the negotiating team. Many of the changes you are making are just completely in opposition and anathema to the entire intent of the bill. We are happy to work with you. Assemblyman Danielson is also my representative. I have tried to reach him many times to speak with him about this bill. I have not been responded to, both as a personal constituent of his and also as the head of a large organization that represents many of the community organizations that all of you care about and support. I know that you don't want your nonprofit members to be spending hard-earned philanthropic dollars to protect homeless people from being sued for getting records that they need. A large portion of our work is now focused on neighborhood empowerment and safety training. We need public safety data to be able to do that work. We cannot get that under the bill that you are considering today. Please do not hamper neighborhoods and community leaders from being able to develop neighborhood revitalization and safety plans by passing this bill out of this committee today. Do not do that to the organizations that you have worked really hard to help amplify and lift up. Instead of being able to help our community organizations and housing developers get land use decisions, minutes, there are some towns that don't put their minutes on a website. You have to file an Open Public Records Act request. My town, where I live in Piscataway, did not used to do that. We had to pass a ballot ordinance to get minutes and agendas public. Every single time you wanted an agenda, you had to file an Open Public Records Act request, and that took 7 days. So by the time you got the request, the thing was over. I understand that, but that's my time as a woman, and I just want to say, I have a tremendous amount of respect and have worked with many of you for many, many years. You've come to our events. Assemblyman Knopf and I worked, communicated about the People's Bill during the pandemic. It was really a refreshing conversation that we've had. I believe that you want to do the right thing. The right thing is to not move this bill today. Please do not do this.
Thank you for your testimony.
Through you, Chair.
Yes.
Ms. Berger, just, can you describe in a little more detail the public safety information that your organizations pursue and how this bill would inhibit?
Sure. So our many of our neighborhood organizations participate in what's called the Neighborhood Empowerment and Safety Training. It's a re-envisioning of what used to be called the Crime Prevention Through Environmental Design tool. It was a little heavy-handed with police, frankly, and so we redesigned it so that it really involved community engagement and wasn't more of a broken windows approach. We request data, our members, and we request data from the police departments in many communities to see where there are lots of issues that are coming up, where there are, where there are arrest reports, where there are reports of criminal activity, where there are reports of people feeling unsafe, or, struggling to find housing in those neighborhoods, excuse me. So we need that data, and we won't be able to get it. Okay, you look like you want to.
No, I'm anticipating.
Okay, yeah, that's okay. We're not going to be able to get that data. I mean, I can't ask our organization, my staff, or organizations that we work with in Patterson or Newark. We've done a couple. We're about to do another one in Camden. We can't ask people to file a request that they may not even be able to get because it might be too vague or it might be too specific. It's hard to know. There's like a Goldilocks spot there, and as someone who's been using OPRA and wrote the law, helped write the law 22 years ago, I don't know what I'm supposed to put in an OPRA under this bill. So I don't know what to tell those folks to ask for, because they need to know exactly what they're looking for. And a lot of what OPRA does is let you look at a pattern or a series of emails or a series of documents, and you can pick out, okay, well this happened on this day, so let me go back and look at the minutes from that meeting, from that session. There's just, it gives you it's not a huge, you can't cast like a huge net with OPRA, but you can cast a fairly wide net so you can get a lot of information and create a pattern of what's happening in the neighborhood or community. It depends on the request, and it depends on the requestor for what they're looking for. But it's not. This is very, very, very restrictive, and basically makes it impossible to do.
Jerome, so you don't request crime statistics. Is that what you mean?
I
mean, you might request crime statistics, but you're not talking about crime statistics now. You're talking about something else. It sounds like.
Well, we're talking about anything that might happen in the neighborhood that would be of concern, and how many streetlights have been called in a community for being out? Is there a particular area where the lighting has been a complaint over and over and over again? So we would want to walk that block or walk those blocks with neighborhood residents and community leaders, but I don't know where that is necessarily. We need to see some data. I'm not the person that runs the program, but we look at what kinds of complaints come in. Absolutely. It's not just crime. It's not only or just crime. There's all kinds of neighborhood issues that need privacy.
Sure. And you feel like you wouldn't be able to ask those questions now under the
under the current law, sure, but not under the bill you're considering today.
And why is that?
For the numerous reasons that many of my colleagues have already enumerated, but I will say it again.
Put aside the fee issue. I understand the fee shifting issue.
Sure.
I think is
The threat of a lawsuit.
The threat of a lawsuit if one makes too many requests.
Correct. Yeah, we ask a lot of questions, and sometimes we have to go back and ask them a second time because we didn't ask them right the first time. I don't know what the standard here is very nebulous.
All right, so it's the fee shift and the threat of the application to the court to kind of tamp down on abuse.
And the specificity issue. You have to ask just the right thing. The porridge can't be too hot, it can't be too cold, it has to be just right. And I don't know how to do that under this law, as someone who helped write the law and has been using it both personally and professionally for more than 2 decades. This makes it impossible.
I'm only an occasional user of OPRA, but there's a degree of specificity that has to be used.
Sure, you have to use it. Right, that's what I said before, Assemblyman. You have to say, you have to ask for a certain person's name or a certain person's email or a topic. You can't just say, give me every email that Assemblyman Weber ever sent to anybody. It has to have a time frame or a topic or a relevant, some keyword. There's to be keywords in it.
But you perceive a different standard in this bill.
Yes, and I think my colleague from the League of Women Voters really articulated it extremely well, so I didn't want to go, because I was trying to be conscious of the time.
Well, I asked you questions.
No.
Now you get more time.
Right. Fantastic.
The chairwoman loves that trick.
I appreciate that you're all here on
Mr.
Friday
Richards would
afternoon.
like that trick too.
You have to know exactly what you're looking for under the way that this is written. And it's a huge burden, especially for nonprofits and for folks in communities who are under-resourced and maybe need additional assistance, and then you can just be rejected. And then if you go back and try to ask the question a second time, well, now are you going to trigger being sued? Maybe. I don't know. It doesn't say in the bill. It's very, very, very amorphous. And when we worked really hard to get the legislation to where it was in 2002, this was an issue. How much can you ask for? How much can you not ask for? you can't get stuff that is, not already a record. So we don't want to make more work for custodians, but we have to be able to ask for something with some breadth, because otherwise we're not going to be able to get anything. And every time we ask, we're going to be told we're asking too much. So then I'm not going to put my staff or our community organizations and partners at risk of being sued. And then I'm going to have to go raise money that I could be using to help house homeless people to pay a custodian who thinks we're asking too much. It's an impossible situation you're putting us in. Please do not do this.
Sure. May I?
Because I have other questions.
I appreciate it. I'm so glad I raised my hand first. Or at least you recognized me first. You were there helping to draft the bill in 2002. You agreed that times have changed. We've learned lessons. The bill shouldn't be the same as it was in 2002, I imagine.
Sure,
Okay.
we can absolutely make it better.
So how do we make it better? What would you do if you were back as manager?
I would talk to CJ Griffin, because they use this more than anybody else and knows this. There's been no negotiation on this legislation. Between us.
But substantively, what would you do to make it better? I mean,
I would restore the fee shifting immediately.
No. What would you, the existing bill today,
I'm sorry, I thought you were.
The existing law, OPRA. How would you make it better?
I mean, I think we can do a couple of things. Sorry, my glasses off. So making, I have used OPRA a whole lot. I don't think it needs a ton of work. I think the commercial piece is a really simple fix, and that is not even in this bill. And that's the main complaint that we've heard over and over and over again from custodians is the selling of the information. When our first dog passed away, we got second dog, we licensed the dog, so you have to do that, and then we got like 27,000, flea and tick, advertisements and all that stuff for a fence. And I mean, it was bothersome, but it wasn't like the end of the world. I think we could look at dealing with the commercial requesters in a much different way than the way that we deal with residents, nonprofits, members of the public. And that's the main thing we didn't really anticipate. I think we can also use technology. I mean, the open machine that is available, that is run by a essentially nonprofit, is a great service. We could make a lot of this stuff just as of right public record. Just put it on the internet. I mean, the internet is a very big place. We can put a lot of stuff there. And it would be cheaper and more effective if we could just look stuff up ourselves.
That is part of the bill.
Well, someone was asking me what, I'm sorry.
No. We like to double team.
It's fine, I'm happy to, there are lots of ways, there are ways that we can address the commercial piece of this and the as-of-right piece. I didn't see that in this bill, but he was asking, I thought what was not in this bill that we should be.
Yeah, how would you improve the bill? So I appreciate it. Chairwoman, thanks for your time.
You're welcome.
Yeah.
Okay, thank you, Assemblywoman. Chair.
Actually, kind of scary. I was going to ask the same exact question as this.
Not scary.
Like this mind melt thing that's happening here. So
The Assemblywoman has so much more in common than she believes.
Well, if 81% of the public thinks this isn't a great idea, I think a lot of us have a lot in common, and we should lean into that and try to
I'd like to, you have someone else.
Oh, yeah, I'm just trying to I'm not trying to.
Do you have a question for this witness?
One quick. Ms. Berger, thank you for your testimony tonight. Just from your own personal experience, it sounds like it's extensive, and we should be tapping into that, I think, in this process. Do you feel it would be easier just to amend and correct the current bill as it stands now, rather than trying to just rework the whole thing like we're doing here? In other words, just you find the inefficiencies, the flaws, you just correct them with the current bill with small tweaks of legislation rather than just one broad sweeping piece of legislation like this?
If I understand your question correctly, through the chair, you're asking if I think we should just tweak the current law?
Yes, I'm sorry.
Okay, I just want to make sure. Yes, I'm sorry, I'm short and you're tall, and so we're doing this little dance where we can't really see each other over the lights. But yes, I think that this bill could go right in the trash, and we could just start over by making very small changes to address the actual concerns that are valid. And I think most custodians want to do the right thing. There are some that have not done the right thing in some cases, but what we really need to do is address the main issue, which, as far as I had heard up until 3 months ago, was really the commercial broker issue, and this bill does not address that, and instead penalizes regular people, working people, parents, active residents, for asking to have access to what they pay for as taxpayers. And so instead of doing this travesty, we could make changes. I'd be happy to work with any or all of you, however, whatever you need from us to get good language, we would happily give you. Let us help you do this well. We can do this. Many of us want to see the changes that we've talked about, making the bill making the process more accessible, more, just less expensive and less cumbersome. But as someone who has used OPRA the entire time it's been in effect, I don't have a lot of complaints about it, except that sometimes it takes a long time for the custodian to get back to you. But otherwise, thank you.
The reason I the reason I asked that question was I was looking at some polling and some surveys that rank New Jersey as like one of the top 2 OPRA states in the nation, and so I just thought we have a model that seems to be revered by some people, and why would we want to just break the whole thing apart and just make the tweaks that are necessary?
I have no idea, Assemblyman. It's an excellent question. Why are we doing this? Why are you all here on a Friday afternoon to gut our pretty successful state law? This is a good law. We did a good thing 22 years ago. Don't break it. Would you like to turn your microphone on, please? And you can testify. Thank you.
Hello, my name is Tanine Howard. I was a principal planner at the New Jersey Department of Transportation. I was a professional planner, AICP certified. My job at the New Jersey Department of Transportation, we were planning for the future, planning for the transportation future, planning for the state plan. So essentially my job was to, get good ideas and stuff in that nature. I was terminated from DOT, which I feel was because of retaliation, because I said they were discriminating against me. They wouldn't allow me to compete for a job that I was qualified for. And through the human resources and through the civil rights, they kind of reverted and they kind of, pushed things under the rug. And when I pursued it, I was retaliated against. They used the Inspector General's office, who's the custodian for the OPRA request, the state police, and New Jersey Transit Police to harass me. I would use the OPRA process. It was the tooth and nail fight every step of the way with the OPRA unit at the state agency. I almost felt like I was fighting with them. I was 2 against 1, and they just had the bureaucracy against me. I got a lot of the records that I requested, but it was a tooth and nail. I knew what I wanted. I was specific, and the organizations deliberately lied and said they weren't there. And some I didn't get. They made me go to court. Several I had to go through the courts. Now I wasn't going to pay all that money for the courts. It just wasn't worth it. But I was able to get some of the information, and I have been able to put some out. Last Wednesday I gave some to New Jersey Transit. You can look at that video. I gave documentation that about the disparities and discipline for black males at the DOT. It was written to Chris Calori when he was the commissioner. He's now running Gateway, and they're putting a tunnel through now. But it was just a tooth and nail fight all the way. I have some of the documentation. I have a lot of documentation, and I've just been keeping them. But it was just a very, very stressful time. They made me work very, very hard to get that. And it wasn't like I was a citizen. It was like I was some communist trying to do something to America, and they were there to protect America, which wasn't the case. I just wanted documentation to prove my case, which I think I have now. I think I have a lot of documentation, and I will be putting it out. But to have the Inspector General's office, who was harassing employees, and you can just go to DOT and ask the employees. Go to the record file employees. Ask them what's going on at DOT. They'll tell you. To have them in charge of the OPRA unit is a travesty. They're not qualified. They're basically a bunch of municipal cops now getting money and patting their pensions or whatever they're doing to harass employees. They use almost like a Gestapo force for the administration. And I don't blame them too much.
Wrap it up, please.
Okay, and I don't blame the state police and the transit police too much because they just follow orders. But that administration you have at NJDOT and that administration you have at that OPRA unit, they're fine. That's it.
Thank you for your testimony. All right, next we have Antoinette Miles, New Jersey, Working Families. Marlene Bell, New Jersey Policy Perspective. Laura, New Jersey Citizens Action. And Patrick Nolan from Rutgers, AFT. Why don't we start over here, and we'll go that way. You're good.
Thank you, Madam Chair, and members of the committee. I wish I could say I'm happy to be here. I'm not happy to be here. The outrage, despite some out of control issues temporarily, the outrage is justified. Not only here in this room, but across the state of New Jersey. Voters are on fire about this issue, and rightfully so. Modernization, yes, no one has a problem with that. Commercial actors, controlling for them, and data brokers, yes, problem not solved in this bill. As a matter of fact, it was referenced, commercial actors now can pay more to move to the front of the line and get their requests fulfilled faster. I, as an advocate, have seen OPRA requests go on for years. The burden being shifted in numerous ways to requesters, unjustified, unnecessary, undemocratic. It basically says in the emails that you must specify the name, the job title, the time period, etc. I want you to know, I'm going to give you one example. I haven't made a request recently, but I recently was in a meeting with the Department of Banking and Insurance. When you enter their office, there's a board with the employees in there that are in charge of departments. Several of those positions are blank. I have no idea who's running the state exchange. If I want to know something, and no, it's not posted on their website. We need to correct things there and not shift the burden. Why are we weaponizing government to sue our citizens? That is absolute insanity. To a panel in the New Jersey Steakhouse about that. I really can. So please forgive my outrage, but the things in this bill don't address the problem that you have. They will limit transparency, they will hurt citizens, and they will put us in a very dark place. And voters can and should be outraged, and we are telling them to be outraged, and hopefully flooding your offices with calls. This bill cannot be fixed before a floor vote in the Assembly and the Senate by Monday. It absolutely must be stopped, and it must be pulled. Please do not let this bill advance.
Please.
Also, I'd like to call up Austin Edwards, so he can be part of this panel. There's a chair right over there. All right, we will continue. Thank you.
Thank you so much, Chairwoman, members of the committee here. My name is Antoinette Miles, and I'm the State Director for New Jersey Working Families Alliance. We are an organization that encompasses not only some of the largest labor unions in the state of New Jersey, like CWA, 32BJ, SEIU, but also many community-based organizations and advocacy and grassroots organizations throughout the state. And so fundamentally here today, I am here to speak on behalf not just the OPRA users, but the taxpayers and the working families that depend on government transparency to advance transformative and meaningful policies and to understand what government is doing to stop waste, fraud, and abuse. I want to be very, very clear here today that there were some amendments that were made that address some concerns, but this version of the bill still will fatally weaken the Open Public Records Act and dramatically reduce the ability for the public to access records. And I really think that we should stop calling this OPRA reform and call it NOPRA, which is No Open Public Records Act, because that is what this bill is fundamentally doing. I think that when the New Jersey comptroller, esteemed as he is saying, listen, I think that this law is flawed. And when 81% of voters are saying, listen, we do not want to have public records limited in such a way that penalizes and punishes the public, I think that you ought to really listen. And so I think that yesterday we heard from many folks speak on behalf of custodians. I worked in the public sector for 3 years for the federal government. I am not a stranger to having the public, come up to you and ask questions and ask for information, right? And I'm sympathetic to those custodians. But when you have a mayor come up and say, and I'm paraphrasing, that too much sunshine causes cancer, what I really want to say is what causes cancer is government secrecy.
Yes.
And so I want to hone in specifically, and as I wrap up my comments, on some of the amendments that have been put forward and why they are problematic, as my colleagues have been saying. Creating a system of haves and have-nots where commercial requesters can essentially pay to jump to the front of the line. I think a lot of custodians are going to be troubled by that, frankly, and under the guise of thinking that we're addressing commercial requests, I think a lot of custodians in local government are going to be concerned about that. And then also, once again, having it so that agencies can sue taxpayers with their taxpayer funds. Absolutely. I think that we must be clear that that is what corporations with deep pockets do. Corporations sue individuals. Our government should not be allowed to move forward in suing individuals. And so please, I urge you today to not pass this bill. Please go back to the drawing board and act in the public interest. We're happy to work with you to do that. Thank you so much.
Thank you for your testimony.
Good afternoon, Chairwoman Swain and members of the committee. My name is Marlena Ubel, and I'm a senior analyst at New Jersey Policy Perspective. We are a nonpartisan think tank dedicated to tax and budget issues primarily, but we also advance racial, social, and economic justice. I am here opposed to this legislation on behalf of my organization. The proposed amendments do little to address the core failings of the bill. They place the onus of the burden on the public rather than on the agency. These records belong to the public. Efforts to erect further barriers to hide documents and records from the public are antithetical to the purpose of OPRA, as Stacey Berger mentioned. New Jersey is already a disgraceful 48th in the nation in public access laws, and will no doubt sink further. Many of my colleagues here today, from League of Women Voters, ACLU, or Family Party, have addressed a lot of the concerns that we also share, so I won't reiterate them, but I'll just say a couple things. One, fewer than 37% of Americans know the name of their congressional representative. Fewer than 37%. How many people know the names and titles and all of the things that we are going to be asking them to do to get access to these records? Much smaller than that, okay? And not for nothing, but recently there was a Supreme Court hearing, and I'll just really quickly say, Ketanji Brown Jackson wrote this. It was about FOIA. She said that the policy of refusing to process requests for emails unless the requester provides specific information identifying the individuals who sent and received the emails, the time frame of the email, and the subject matter of the email constitutes an illegal policy or practice under FOIA, and she recommends that the agency discontinue that policy. And here we are today trying to do that in New Jersey. So I urge the committee to vote no on this bill. These amendments have failed to address our concerns. Thank you so much for taking our testimony.
Good afternoon, I'm Patrick Nolan, I'm the Executive Director of the Rutgers AAUP AFT. I'm here on behalf of over 10,000 AAUP and AFT members across Rutgers University's campuses and at the New Jersey Institute of Technology. I haven't heard anything today that suggests there's an emergency and this bill has to be passed on Monday. I've actually heard mayors say they are for transparency and that from everything he heard, we're not that far apart. So why wouldn't we take more time? It makes me wonder what is happening in the town of Woodridge, New Jersey.
What's happening?
That we had to meet here today on Friday. It's commencement season. Many of us could be elsewhere. It's the beginning of Mother's Day weekend. And yes, my wife claims the entire weekend. She deserves it on Mother's Day. We shouldn't be here. We really shouldn't be here at all. The process of democracy should be nonpartisan. Democracy itself may get partisan. You may join together and do bipartisan things. But the process, the access to information, is part of that democracy. That should be nonpartisan. We should be passing laws that restrict as little as possible access to information. We want an informed electorate. We encourage people to vote. We protect voters' rights. We pass laws to do that. And I know those generally to my left generally have a philosophy of only passing laws when you feel it's necessary. And those to my right generally want to protect voters' rights broadly. Those are not mutually exclusive. So I think that can be a bipartisan issue. And I encourage that today. This is the Appropriations Committee. What is happening in Woodridge, New Jersey, that I sat in a budget-only hearing yesterday on higher education services that started late and ended early to focus in on this OPRA bill? What is the emergency that this bill has to be passed by Monday? The only thing worse they could do is to schedule the final vote on Mother's Day. So I encourage you, I've heard some really good questions. This is the deliberative space. Monday's not the deliberative space, right? This is the space for you to hear from us, not limit us to 3 minutes, or to limit us to one representative per organization, or to ask colleagues to talk to the sponsor. What could happen between now and Monday to talk outside of this space about a bill? I say, if you want to pass a bill, and this is the Appropriations Committee, pass a bill that appropriates $8 million to digitize and modernize the process of OPRA.
Your testimony, you're right on time. Next.
Sure. Members of the legislature, my name is Austin Edwards. I serve as Senior Policy Counsel for Salvation and Social Justice. Our organization is a Black, faith-rooted, nonpartisan social justice organization that seeks to liberate public policy theologically by modeling the hope and resiliency of the Black faith. For years, we fought alongside many of you, community leaders, advocate partners, and the directly impacted to bring about a more just and equitable state for all of New Jersey residents by working to ensure accountability and transparency within the state entities whose policies have historically targeted and harmed Black communities throughout New Jersey. I'm going to take most of my testimony instead of reading all of the things submitted, but harkening back not too far ago to the Seabrooks, Washington bill, which we worked with many of you to pass. And if you're unfamiliar with it, it specifically had two of the street teams members in Patterson and in Newark, right, who were unjustly killed by the police, which prompted more funding, more ability for local communities to be able to police themselves. Unfortunately, because of their loss of life, we had to go through the routine OPRA process. And it wasn't just these two individuals. It happens far too often in New Jersey, where we often have to seek records, often have to find the data, often have to compile this information in order to craft good legislation to help New Jersey residents. It is through the current OPRA law, not the one that we want to propose, not the one that's going to be voted on today, not the big piece of mess that we have in front of us. But through that, and even the difficulty with the current OPRA laws, we still had to overcome that just to make a good piece of legislation to benefit New Jersey communities. So I'm testifying here today. Yes, we're concerned about a lot of the provisions, right? Specifically, fee shifting is an issue. Specifically, having the government being able to sue members of the public who are requesting this information. But other points we especially want to highlight at Salvation and Social Justice. We can't forget the task force that was in this original bill. I've testified on this a few times now. And the first problem is that it seems to get worse every time. The task force originally was staffed with mostly police. Now it doesn't even exist anymore. You know, one of the things that we were hopeful where we could get more access to police records, get more access to important pieces of information completely gone. This continues on and on. This piece of legislation before you is absolutely terrible. Would hinder our ability to get information to protect our New Jersey residents. That's why we're testifying here today to vote this bill down in its entirety. Thank you.
Thank you for your testimony.
Many of you will be asking us.
I'm sorry you had your time, and
I'll just say,
for everyone.
in the fall, you will be asking us to help defend democracy. Let's defend it today.
Defend it today. Defend it today.
Okay, thank you all. Next up, John Donadio and Lori Buckaloo and Bill Caruso, New Jersey Association of Counties and New Jersey League of Municipalities.
Good afternoon, everyone. Thank you for the opportunity to speak. My name is Lori Buckley, Deputy Executive Director for the League of Municipalities. As you heard from some of our mayors earlier today, we're here to express our support of A 4045, which makes various reforms to the Open Public Records Act. The League and our members strongly believe in an open and transparent government. The citizens and residents must be informed about the workings of government to participate in this democracy. At the same time, we must protect taxpayers from the abuses experienced under OPRA. The amendments to A 4045 are a positive step forward to modernize and reform OPRA. As amended, the legislation effectively addresses privacy issues, makes it easier for residents to access government records online, defines commercial records, streamlines the administrative process for records custodians by maintaining access to records and transparency, and provides a long overdue level playing field regarding prevailing attorney fees. The bill implements from 2004 Privacy Study Commission the recommendations. It's important to note in 2002 when OPRA was signed into law, at that time the legislators recognized that they didn't adequately address privacy in OPRA. They impaneled the Privacy Study Commission, which met and had stakeholders from all groups meet, deliberate over 18 months and come up with a list of recommendations. Finally, 18 years later, those recommendations are being implemented in this bill. So the Privacy Study, under this, debit card numbers, bank account information, month and date of birth, names, home addresses, and personal email addresses will now be redacted from government records. In addition, and it's only for residents, public officials, official addresses and email addresses still need to be disclosed under the law. It's only for the private citizen interacting with government. The bill also addresses burdensome commercial requests that continue to increase year after year. Since enactment of OPRA, commercial enterprises has abused the legislation as a mechanism for commercial purposes. Their actions have cost businesses themselves little to nothing, but the public entity expends resources in response efforts, thereby transferring OPRA into a commercial tool was never intended to become. Again, under the bill, residents and the press who are exempt from the definition of commercial, and also I would note that nonprofits are exempt from the definition of commercial as well, are still able to access government records. What would stop is residents receiving unsolicited solicitations simply because they filed a permit, licensed their dog, or participated in a recreation league. We thank the sponsors and urge the legislature to pass A 4045, which preserves government transparency and public access to government records by making common sense reforms.
Thank you for your testimony.
Thank you, Madam Chairwoman, members of the committee. John Donadio with the New Jersey Association of Counties. I first want to thank the prior panel for reminding me that Sunday is Mother's Day. I'd be in bigger trouble than I already am. So we too also support the bill for the reasons stated by Lori Buckaloo, but we also, because the legislation encourages municipalities and counties to digitize their documents and to post records online. We think that's a critically important component of the bill, and I can tell you from the county perspective, that's going to significantly save time and resources, and it's a welcome encouragement, in addition to encouraging the sharing of services as well. So we think that's a really positive piece in the legislation. The other part of the bill that Lori, I think, touched on a little bit is the fee shifting. That's important to us because there are plaintiff attorneys, and this was discussed at length yesterday, that make well into $500 an hour. There has to be some type of controls in place because these fees are paid for with property taxpayer dollars, and it's not always because the custodian of record is acting in bad faith. There could be a dispute on the legal merits or the facts of the circumstances, and I think that there needs to be some kind of control. And I would argue that the legislation doesn't go further enough. We'd like to see, and I've been asking all along, for a cap on those fees, and whether it's tied to what local governments pay, or Chairman Sarlo yesterday suggested a cap of $300. That's a significant amount of money that I think is a fair and reasonable amount, and I think a reasonable request, because again, these claims are paid for with property taxpayer dollars, and you know, as sitting here representing counties and municipalities, I know John Burns with the school boards couldn't be here as well. We're struggling with these types of issues, whether it's excessive attorney fees, health benefit increases, pension increases, the cost of goods and services. Something just has to give. And I think that this piece of legislation is a step in the right direction for that reason and for the other reasons already stated. So we support the bill. Thank you.
Thank you for your testimony.
Madam Chair, members of the committee, my name is Bill Caruso. I have the pleasure of serving as Legislative Counsel of the New Jersey Conference of Mayors. I associate myself with the remarks of my smarter colleagues here, and also associate myself with some of the remarks of some of the critics. We don't think this bill goes far enough. We had mayors testify on that account yesterday and again today. We would have liked to see the bill go further than it is. But this is a legislative process, and you don't get everything you want all the time. I'd also like to address something regarding the legislative process. We sat here in lame duck last year. We discussed items related to affordable housing, and those were tabled into the new term and worked. And those issues are now law. Landmark legislation passed. It wasn't perfect for everybody, but it is moving. And there may be opportunities to come back and deal with that. Today, May 10th, where there were complaints made by some of the opponents of OPRA reform that it was moving too fast, then in lame duck, and it was going to be jammed down people's throats. The Speaker, the Senate President, you folks in the legislature waited and have run a deliberative process. We have done more hearings on this bill and OPRA this year than I think we've done in a decade. This law is 20 plus years old right now. It is long overdue for some modernization reform. I'll say something else that I don't do normally. I'm going to associate myself with Assemblywoman Weber's remarks in that there's always opportunity in modernizing what we're doing. I think you all are doing that. Is this perfect? By no shot. But I don't know that there's ever been a bill that's passed here and signed into law that is. If it's not done in a manner that we all think is going to happen, or if some of the concerns that are being raised out here do manifest itself, nothing stops you from coming back and fixing some of those issues and addressing them. But we have not done the work we've done to protect local government, protect citizens, and absolutely help modernize this process by giving the authority to clerks and municipal governments to put things online, to make it easier for people to have the ability to go look for this there rather than waiting to figure out whether custodian of records is going to respond. I am therefore, on behalf of the Conference of Mayors, very pleased to support this bill and your effort, and I'm really hopeful that we're able to get this out today and get it moved. Thank you very much.
Thank you for your testimony. Okay, that's it for Madam Chair. Yes?
Thanks for the testimony. I can't say I disagree with the issues that you've pointed out. We've spoken to mayors, all of us have spoken to mayors in our district. And that's why it makes this a difficult thing to be dealing with, because there's legitimacy to both sides of this. So my question is, if the bill did not get released, let's just say, for example, it didn't get released for today, I'm guessing it's probably going to, but wouldn't there be an alternative to this? In other words, I'm just kind of looking at it like we could surgically just address the issues that aren't functioning properly or have been manifested as being abused and correct those things, item by item, bill by bill, where we could get the stakeholders who are directly affected by these particular things come into a room and say, this is what we can live with, this is what we have difficulty with, sort it out, and one piece at a time, rather than just say, we're going to use a sledgehammer, and we're going to perform surgery, and this is what you're going to be dealing with now. And then maybe we'll figure out what's wrong with this new bill and try to surgically take pieces out, and that could go on for another 20 years. That seems counterproductive to me. So I'm just looking at it like, okay, we don't want to throw the baby out with the bathwater. We got something that has ostensibly worked pretty well. We found some flaws. Let's fix the flaws. Is that something that you guys could deal with, or am I off base? You know, I'm looking to learn here. I don't know everything, so please help me.
You know, if I may, Madam Chair, I think Billy Caruso pointed this out. It feels like we've been at this for a really long time. I mean, decades, starting with pieces of legislation that Senator Weinberg then introduced, and we met, you know, with the senator on some of the concerns that we had, and some were addressed in her pieces of legislation that never made it through the legislative process. But there's been 4 hearings, and I can tell you that we've met and had stakeholders from our side, meet with Senator Sarlo and the other sponsor several times over the past couple of years. So I don't know. I mean, the legislation that we have here today, we're supportive of, and I think we're okay with that.
All right, thank you. I'm going to call for a vote.
Madam Chair, I call for a motion to release the amendments for Assembly Bill 4045.
Is there a second? Second. Thank you. Roll call, please. On motion to amend and release Assembly Bill number 4045, first reprint. Assemblyman Meyer
Yes.
is a yes. Assemblyman Off
No.
is a no vote. Assemblyman Weber has left an abstention. Assemblywoman McCoy.
Chairwoman, I think that there's no denying that this report needs to be updated, and I'm sure believe that we need transparency, but I do believe that there is some abuse to OPRA, and so looking at the current amendments, and I think obviously we definitely need to look at some other significant shifts as well, but I am going to move this bill forward. So yes.
Assemblywoman McCoy, yes vote. Assemblywoman Tucker.
I'm going to vote to release the bill from the committee, but I consider my rights.
Is a yes vote. Assemblywoman Mathis.
Thank you, Madam Chairwoman, for conducting the meeting in which you did in reference to hearing from individuals who have spoken in many different facets, and for all of us and for those in the room. For me, it's not just about the hearing today, it's about listening to what happened in the Senate the day before
to continue to educate ourselves. And I shared with somebody that, when I reflect upon pieces of legislation of this sort of magnitude, I look at it from the aspect of, a resident, a constituent in my district, and how will this affect them? Because they're the ones who don't necessarily always have the voice. Businesses typically have a larger voice, and we're typically in tune to the businesses. I was at a town hall meeting, I was a panelist on a town hall meeting, and a good friend of mine, who I haven't seen for a long time, who has a special needs child, came up to me and she says, and I was really surprised. I said, Pam, I'm really so worried. What are you worried about? And so, because she's had problems with group homes. If this piece of legislation goes through, how am I, the mother of a special needs child, going to find out where the next place that they want to place my child, whether or not that next place has had violations, whether or not that next place, is a good place to be able to place my precious child? And I related it just to that story. And from what I've heard today, and from what I've heard previously, my grave concern is this, is that she might have to have multiple attempts at actually inquiring, for her child, in which case that would be curtailed. She herself can't afford to be able to hire a lawyer at $500 an hour. So her choices are going to be curtailed. We all want those who have, who don't have a voice, who have special needs, who are the most critical, in our community, to be able to live a positive life. And I'm very, very concerned that with limiting, rolling back some of what we rolled it back too far. As someone Weber was going to ask the question that I was going to ask, I might have phrased it a little bit differently. I would have phrased it as such, where would you have found a little bit more compromise? I know that discussions have happened. Discussions have happened. If you have not had a voice at the table, then I don't know why, but I know that a lot of conversations have happened. Where would you find compromise from where we are today with the bill? And where would you want, to put your one or two top priorities to make changes to effectuate a lot of the people that I just spoke about? So at this point in time, I'm going to just vote to release, but I have grave concerns.
Farrell. Excuse me.
Assemblywoman Blackman is a yes vote. Assemblyman Atkins.
Thank you very much, Madam Chair. I am voting yes to release. I do know that there was several conversations and there's been several amendments to this particular item, and as we move forward, I'm sure that there's going to be continued conversation. But as a co-sponsor, it's a yes.
Is a yes vote. Assemblyman Rodriguez.
My vote is yes.
Is a yes. Chairwoman Reynolds Jackson.
My vote is yes.
Is a yes vote. Chair Swain.
Firstly, I want to thank everyone who came out to testify today, whether you were in favor or opposed. I think that for the most part, we had a really robust discussion today. And I'm really happy to hear all of the engagement, and it gave me a lot of things to think about. I'm a former mayor, so I've been dealing with OPRA issues for many, many years, and I've seen, unfortunately, the negative side where my town has had to hire extra people, and I know this to be the case for many towns where they've had to hire extra people, and of course, we all as taxpayers have to pay for all of that. On the other hand, the advocates who were opposed to this brought out some, really relevant information. So with all that in mind, I'm going to vote to release because I want to continue to think about this and review those amendments again, and we'll see where it goes from here.
Chair Swain is a yes vote. Assembly Bill number 4045, first reprint, as amended, is being released.
Thank you, everyone. Have a good weekend.